It's early here in the States. I really wish I were there in London with all of you. I know I speak for Andrew, he does as well. But I wanted to introduce myself. I'm Christi Cannon. I know many of you, those that I don't. I am the VP of Global Class Actions at Broadridge. We represent 850 financial institutions for portfolio monitoring and class action and claims filing globally. I've been specializing in class actions and collective proceedings for more than 25 years as a litigator, which is where I met many of you in the audience, and as an executive in global claims administration and asset recovery. I'm excited to be the moderator of this panel today about a topic that is of interest to all of us, the settlement of global disputes. As we all know, and as will be discussed over these 2 days, the number of global jurisdictions embracing class, collective, and group proceedings continues to grow. We at Broadridge are currently tracking opportunities in 35 plus countries right now for asset recovery opportunities via class and collective proceedings. We all see the headline settlements being achieved across the globe, certainly in the US, but also Brazil, the UK, Germany, Japan, and just this week, China. A single fact setting, as we all know, can generate multiple litigation avenues and settlements for recovery for claimants. Further industries are definitely becoming more global in nature. They're providing goods and services across borders and territories that have different norms and processes for litigation. Combine that with the impacts of COVID and the leap that took place towards digitization during that pandemic. So whether it's securities litigation, consumer litigation, or mass tort, mass injury litigation, there is bound to be parallel litigation somewhere else in the world that could either provide a path to asset recovery or have an impact on a claimant's recovery rights in the parallel proceeding. So we're going to be talking specifically about the settlement of global disputes and addressing the growing need to evaluate and manage competing and complementary multi-jurisdictional settlements, including talking a bit about the interplay between North American and European settlement schemes, and also how increasing digitization is impacting cross-border settlements. We have a great panel today. We have Kathleen Doyeux, who is an attorney with BCV Lex in Bordeaux. The firm also has a presence and office in Madrid. They represent more than 3,500 individuals in claims with cross-border aspects, including in defective product litigation, consumer litigation, environmental disasters, and air, sea, and land accidents. We also have Andrew Hill, who's also on the display with me. He is an expert in UK securities litigation and group class actions. Andrew has been at the forefront of developing securities litigation in the UK since 2014, identifying potential recovery opportunities for institutional shareholders there against UK public companies. He drove the launch of the UK's first such claim against a PLC. That is, of course, the high-profile £4 million case filed against Tesco in late 2016. That case was settled successfully after he joined his current firm, Fox Williams, where he has just settled a second securities litigation claim against Tesco arising out of the same facts for a larger group of institutional investors who issued proceedings just before the limitations period expired. We also have Dave White. Dave is the Vice President of Business Development for Blackhawk Network. He has more than 20 years of payment program management experience. You may not think you know Blackhawk, but you are likely a customer of their grocery store gift card malls found in retail establishments around the globe. I know that I certainly am. In addition to retail, Blackhawk is also one of the largest B2B payment providers, issuing over $27 billion in payments and incentives across a variety of industries every year. So really glad to be here with this panel today. During prep for this session, we all talked at length about several challenges and complications from an investor's perspective and from their counsel's perspective that can occur where there are competing or complementary global settlements. So as we dive into this, just so you are aware, the takeaway to these very sort of nuanced questions that came up, we all acknowledge that the right approach to protect and convert asset recovery rights isn't always clear in these settings. It very much differs from case to case, from case type to case type, and from country to country. However, We're going to explore some of these issues and identify some guidance regarding same, introducing some case studies where we think that they're helpful to sort of illustrate the issues. All right, with that lengthy introduction, thanks for your patience there. Let's start on our first set of discussion topics. Andrew, I wanted to talk to you about this first. Our first case study is one that I mentioned already. That is the Tesco Securities litigation, in which, as I understand it, there were UK civil and regulatory settlements, as well as 2 cases in the US that settled. Can you talk to us a bit about how those settlements illustrate some of the challenges that we all talked about during our prep for this panel?
Absolutely, Christi, thank you. And thanks everybody for joining. I'm sorry I can't be there. COVID finally caught up with me. So I'm in isolation in my flat about 2 miles away from where you're all sitting. But nevertheless, I'm happy to join you. I guess before I dive into the Tesco case study, I thought, I just wanted to say, we're trying to talk about issues of, global disputes and the settlement of global disputes, but, and we'll do our best to do that. But, until we have some sort of supranational international court for collective redress, which is an idea that has just dawned on me, we do inevitably have to deal with domestic considerations for global disputes because we're tied to our national laws or our national courts. So I think the key takeaway from this panel, I hope, will just be an appreciation for you guys of the different challenges that arise in these sorts of cases and how we can collaborate to assist the claimants at the end of the day. So talking about the Tesco case, I'm going to try really, really hard to keep everything I say to matters of that are in the public domain. And I think I can do that. And also to pick up on something that Jeremy Marshall said from the previous panel, securities litigation cases in the UK are difficult, but they can be successful and results can be achieved for claimants. And the Tesco example is a good one for that, from the claimant's point of view, at least. The facts will be familiar to I'm sure many of people in the room, but just very quickly, the case arose from an overstatement of income in the company's accounts in 2014, August 2014, which was then corrected in September 2014. And in fact, Jeremy and I were involved right from the start, towards the end of 2014, trying to put together a group action on behalf of investors, right from the get-go at that point. So I've worked on that case for a long time now, in 2 respects, at 2 different firms. But in short, there were 2 claims brought in 2016 for different groups of investors. Those cases, and remember we're talking about settlement in this session, so I'll jump to the end. Those cases settled in 2020, so just last year. Interestingly, they settled before the limitation period expired, although settlements were announced before the limitation period expired. And so I was involved at Fox Williams in putting together a second group of investors to sue the company again, arising out of the same set of facts. And another firm, my previous firm, went round again as well for a second group. So in the end, Tesco has faced 4 group actions arising out of the same litigation, each of which have now settled. That gives rise to some questions, I think, which might be better dealt in a different panel about, opt-in versus opt-out, and the mechanisms we have available to us in the UK at the moment. But as it stands, they were all opt-in institutional investor cases, and each of which have now settled confidentially, of course. But as Christi said, there were lots of other dynamics at play over the last 6 or 7 years for the company and for the claimant groups in trying to get to this point. As I said, the sort of scandal erupted in 2014, late 2014. By Christmas of that year, the FCA had announced an investigation, and then also the SFO, the Serious Fraud Office, had announced an investigation into Tesco, both of which proceeded from that point. We, on the claimant side, continued with our book building efforts, and as I mentioned before, when we got to 2016, summer of 2016, and then October, we were ready to file, and so we did file. Interestingly, we hadn't heard from the FCA or the SFO during that period of time. We didn't really know what they were doing. And it wasn't until 2017, March 2017, after we'd launched the first of those actions, and the second one had followed us, that the UK regulator, the FCA, came out and issued a finding of market abuse against the company, and required the company to put in place a compensation scheme for investors. So that gave rise to a bunch of questions for us, really, and for our claimants, about whether or not to participate in the compensation scheme, drop out of the group action, stay in the group action, do both. All of those we had to try to consider and advise them on. And it was a complete sort of curveball. I think at the time, the FCA said that was the first time they had required a public company to put in place such a compensation scheme. So it was new territory for all of us. So we had those factors. Then at the same time, the SFO entered into a deferred prosecution agreement with Tesco stores, the main subsidiary, and compensation, I think in about £130 million odd, was paid to the SFO for that. And then there were 3 prosecutions against 3 of the former senior executives. So there was a lot going on around and alongside us and what we were trying to do in the civil litigation. But it was I think it's a good case study or a good example of all the different factors that can be at play when you've got such a large scale scandal or an event, to use a neutral term, that it had an impact ultimately, I think, on how those cases were settled. Again, as Christi mentioned too, there were, I think, at least 2 class actions on behalf of US institutional investors in the US, I think based on American depository receipts and F shares. And so they were launched quickly, as tends to happen, and they were settled pretty quickly too. That was in the public domain. So we had available to us as claimant lawyers in England, I guess a range of different mechanisms and results which started to come through. We knew what compensation Tesco had agreed to pay through the FCA's scheme. So we knew the inflation in the share price, which they were prepared to admit to, or had to admit to. And we knew out of the US class action, the settlement amounts that were paid there. And we tried our best to guess, at what level that was on a per share basis. But there were a lot of those factors at play that we tried to kind of synthesize and then to use in our favor in our negotiations with the defendant. I should say, as Christi mentioned, I left my previous firm when the first case was still ongoing, and it settled after I had moved to Fox Williams. But then last year, we took the opportunity to form a second group. So I looked at these questions at sort of both ends when they were happening at the time on the first case, and then subsequently on my second case, looking at whether or not, say, an investor who came along and said, I want to sign up to your group, but actually I did take the FCA compensation back in 2017, 2018, or I think I was in the US class action, but I'm not sure. Can I join your group? These were interesting exercises and analysis that we had to go through to try to figure that out. To begin with, whether or not they could join, and then that also had a role or formed a part of the negotiations that we ended up happening with Tesco. So in a very quick way, Christi, that's it's an example or a case study of an English securities case, but which had certainly had multiple civil and regulatory dimensions in the UK, but also the international factor of class actions in the US in relation to different securities of the company. And
so
it's taken to take on board, but
sure. No, I think what's interesting about this particular case study and why I thought it was helpful for this audience today is because it really did cover and address several of the issues that we all talked about when we were doing our panel prep, which includes when you're looking at multiple global settlements, whether they're regulatory, whether they're in one country or another country, whether they cover different securities, the same securities, different class periods, the same behavior, slightly different behavior. Investors really have to think about navigating the expiration of their claims. Certainly that was something that came into play here. They have to evaluate sort of the competing civil and regulatory opportunities. Sometimes those can be complementary, sometimes they can be competing. I think that does vary by jurisdiction. They had to think about the complementary proceedings in multiple jurisdictions. You mentioned perhaps as an investor, in order to get a full recovery across all securities investments. In Tesco, you had to participate in 2 different countries. You have to think about the foregoing of rights. If you're participating in one case, to your point, if you've already participated in one recovery, how does that impact? What is the scope of the release? Sort of what is the scope of what you've agreed to? And then all of those issues that came about as we were talking about the challenges when there are global settlements really are sort of teased out in this sort of Tesco situation. So I found that one to be very interesting. Are there any conclusions or guidance other than, have really good counselors and be thoughtful about casting a very wide net when folks are evaluating these opportunities?
I think I would say, Christi, like as you just did, from the shareholders' point of view, it's really important to take a broad approach and just to be mindful of all of the different schemes or remediation programs that are put in place, the options that you might have. You might be a bondholder as well as a shareholder. You might have ADRs in the US. You might also be investing on the London Stock Exchange. You might, as a claimant, actually be entitled to compensation and redress on multiple fronts. I'd love to do all those cases for you if you're that investor. I think it's just, I guess, being mindful of those, but then, and from the lawyer's point of view, acting for a claimant in that situation, again, it's just trying to be aware and trying to factor in, different settlements that were achieved in different jurisdictions. We certainly tried to take a principled approach in our claims of saying, well, investors should be treated. We would hope that investors wouldn't be treated differently, so that if you can sort of use, for instance, the FCA compensation scheme as a sort of benchmark. Well, as it happened as a matter of public record, Tesco paid 24.5 pence per share to investors in a particular time period. So there is some level of acceptance there of a degree of fraud on the market or an inflation in the share price. So knowing about those and obviously being aware of them and then factoring them into your own case, I think is
important for sure. Okay, let's turn then to a consumer case, one that we're all very familiar with, right? The Dieselgate consumer cases. This particular case study really did, for the folks of us on this panel, again, highlight some of the issues that we all face in navigating when there are competing complementary global settlements. So I note that in addition to 2 of our panelists, Andrew and Kathleen, who have each have some real world experience with some of the Dieselgate consumer cases. We also have attendees, I believe, in the audience today from a stick team for the Diesel Emissions Justice Foundation. So there'll be a lot of resources if anybody has follow-up questions during the breaks about the Dieselgate consumer cases. I'm sure that any of those people would like to talk to you. Let's talk again about sort of how this case illustrates some of the challenges. Andrew, will you kick us off on that? And then I know Kathleen, you and your firm had experience in these cases on behalf of some French consumers, and I believe also some Spanish consumers.
Yeah, absolutely. I'll repeat what Christi just said. I'm sure there are people in the audience with much closer knowledge of these cases than me. I've followed them obviously closely as someone who's interested in collective redress in the UK, and also had some quite close dealing or did some considerable work in relation to a potential Dieselgate claim against Mercedes, as it happens, not Volkswagen. But I mean, Volkswagen, we're all familiar with, but if you just step back and think about it from both the defendant and the claimant's point of view, there is litigation against, or has been litigation against Volkswagen arising from that scandal in the UK, in Germany, in the Netherlands, in the USA, Canada, Australia, probably 20 or 30 countries, if not more, around the world. There's also been, regulatory and civil enforcement actions against the company. It's a good example of how, you can have securities litigation and consumer litigation running side by side. It happens to be in Germany because that's where the company is listed. So there's the securities cases for shareholders against Volkswagen there, but also the very, very, very many consumer cases against the company in Germany and across Europe. Some of those have settled, and I think it's really interesting from a sort of policy point of view to think about or to look at this sort of a global dispute and think, well, how is it that, or why is it that a defendant might settle in the US or in Australia, for instance, but then choose to fight in other countries like Germany or in the UK? And again, I'm sure there are people in the room with better answers than me on this. I don't know really why would a defendant take that view. I suppose there are things like, obviously assessing the risk in each jurisdiction. The law in each jurisdiction is going to be different. So some cases you'll want to get out of the way. You don't want the potential for a jury verdict against you in the US. So, there'll be pressures in certain jurisdictions to settle, which perhaps aren't going to be there in others. So you might choose to fight them in others. But, like on my little Tesco example, it does throw up some interesting considerations when you know that a defendant has settled in a different jurisdiction. You might know how much they've paid to the consumers or the owners in those jurisdictions. So it's certainly something you want to know about as a claimant and a claimant lawyer, and to factor in to your considerations how the case has been dealt with in different countries and how it's been settled, if it has, in different countries. In terms of the UK case, as far as I understand it, it's slowly moving towards trial in 2023. I think that's the latest intelligence I have on it. There was a really damning finding against the company last year, so I had thought perhaps settlement might have been in the offing after that, when the court established that, yes, there were defeat devices in those cars, but again, the defendant is defending the case, so it's moving towards trial. I think, for me, one of the big questions that comes out of these sorts of consumer cases, well, there's probably a couple of them, but from a settlement point of view, depending on when the settlement happens, there's a real question about the integrity of the book, your group of claimants, if you're acting for them, because, in the UK, the obvious point is outside the competition space. These have to be done as opt-in cases. So as Lockie was talking about in the first session, as others will across these 2 days, that requires book building and a huge amount of investment up front in the UK to form those groups. And if you're doing them on, via websites and trying to do it on a mass basis, there is always a risk, excuse me, that, you'll try as hard as you can, but Mr. Smith might sign up to your group and might sign up to the next firm's group and the next firm's group. And you might think that you have 10,000 claimants in your group, but, a proportion of them might have signed up to multiple groups. And unless there's until there's some sort of shakedown of the various groups, there is a risk that you don't act for quite as many people as you think you are acting for, or at least you're going to have to divide those up between the firms when you get to that point. And I think that represents an interesting challenge, potentially, if you're doing an early settlement before a GLO was ordered or other, the court might have stepped in to try to resolve those points. You'll have to try and figure out, how to address that with the defendant in a commercial negotiation and with the other law firms if they're all involved in a sort of multi-firm settlement, or if you're just trying to settle off your one group.
Right. Kathleen, with regard to Dieselgate, so I know that your firm worked with a group of French consumers. Can you talk to us sort of about how that case proceeded and the status of it? How did it, I believe it settled, and how did it sort of coordinate with the other proceedings that were going on?
Yes. As Andrew said, there are a lot of actions filed against Volkswagen all over the world. Our French-Spanish law firm is involved in supporting several thousand of clients in the Dieselgate case. We brought the action of our French client before the German courts, but outside of the framework of the class action. With our client, we joined the action already filed by our German colleagues with whom we participated in the study of European law. We carry out comparative law, we carry out individual settlement, enabling our clients to be reimbursed for their purchase price minus the mileage of their vehicle, without them having to return the vehicle. This is a great victory for our clients, and we are delighted for this. Volkswagen decided to settle the case without asking the return of the vehicle. We suppose that Volkswagen is not interested to get the return of millions of vehicles. Currently, our Madrid office is acting on the behalf of Spanish clients who are awaiting compensation for their loss. The action on behalf of 1,500 clients has been brought before the German courts, and currently we are waiting for the judgment. The action of the others 5,500 clients have been brought before the Spanish courts, and this case are at the stage of discussion about the choice of the applicable law.
Okay, great. So I think this is an interesting case study. Obviously we in the States had a very large program here as well. I think one of the largest programs ever in reaction to the Dieselgate cases. And it just illustrates that, look, wherever you sit sort of in the world, there are actions taking place and decisions being made and settlements and concessions being made that really could have an impact. Maybe possibly not on the resolution of your matter or the timing of it, but how much you actually receive in the ultimate resolution of the matter. To your point, Andrew, these cases are parallel, but they can have very differing lengths of litigation before a settlement is reached. And being able to sort of take all of those things into consideration as counsel to a consumer group is super important in understanding how they fit together. I also thought it was very interesting. We were talking about this particular case, the level of formal and informal collaboration across group counsels for the different groups and the different proceedings. I think in some instances it was more healthy, in others it was possibly less, but in any event, it definitely demonstrates the opportunity there to be aware of all these proceedings and understand how they might impact one another as they're resolving. Kathleen, oh, go ahead.
Sorry, Christi. No, just another point I thought was worth drawing out from this case study, and certainly something that we were really conscious of when we were looking at the claim against Mercedes, but the same would apply to others. Where you've got litigation going on in different parts of the world, and which may settle or resolve differently, obviously, in those countries. It's obviously, I think, important to keep track of all of that, and so be aware of, for instance, how much or the settlement that Kathleen's firm was able to obtain for her clients. How does that compare to other settlements that have been offered by the same defendant in relation to the same conduct in different parts of the world? I think that's key. But one, I suppose, risk that I thought of, or we thought of, and without wanting to give away or give any tips to defendant lawyers, but I'm sure they've thought about all this themselves already. But the question of non-monetary compensation, which I think hopefully is something that Dave can pick up as well on when he comes to his contributions. The settlements, as far as I understand it, in the US, for instance, against Fiat Chrysler and against Volkswagen, and also against Mercedes and Daimler, they did involve not just cash payments, but also the offer to consumers of, if you wanted to keep your car, extended warranties, offers of repairs, as well as civil penalties, and sometimes buyback options. Mm-hmm. But it was really important, and we were certainly nervous when we were thinking about forming a group and how we would structure that financially, commercially, to make sure that there would need to be a cash component somehow or other in any settlement or award, because particularly in the UK, with no class action settlement regime, no approval of the court required, you could have a situation where the claimants are offered compensation, but it's non-monetary, and there's nothing for the claimant lawyers or the funders to recoup from. So that was something that we were certainly conscious of.
Sure. So let's jump over to something that you just mentioned, and have Dave talk to us for a bit about the impact of digitization on payment and distribution programs. That landscape's certainly changing due to some of the leap toward digitization that we experienced during the pandemic, and also there's the increased globalization, cross-border activity, lots more engagement by companies in multiple jurisdictions, obviously, where there can be some of these competing recovery options. So we thought this was a really interesting topic as we were getting ready for the panel. Dave, tell us what you're sort of seeing and from your perspective, where you sit at Blackhawk, on payment and distribution changes that are occurring in global settlements.
Yep, absolutely. So, and Andrew, thanks for bringing that up. As a payments company, I'll say that we're a big fan of monetary compensation as opposed to non-monetary compensation. But certainly from an evolution standpoint, as Christi mentioned, Blackhawk issues payments and incentives across a variety of industries. And the evolution of payments and the way consumers interact with them. Our focus is on consumer class action in this particular industry. What we've seen is the evolution of acceptance of payments is not unique to this space. What is unique is that because of the regulatory nature of class action, is you may be several years behind in terms of what consumers are actually accepting in other spaces, whether it be for promotions or incentives or payments in insurance, in financial realms, in automotive and utility, and various other places where they're accepting compensation. So where we see the change and we look at the driving factors that, that go into the decision as to what payment is selected. Convenience, security, cost are really the three main drivers. And if you look at the predominance of what we've seen for payments, and in particular in a lot of United States cases, as well as other parts of the world, checks, paper checks, mailed paper checks have been popular in years past. That is phasing out. That is all phased out in other industries, whereas in this industry, we still see there are some settlements because of the long tenure of the decision process that checks are still written into it, but we see that going away to Christi's point of everything is digitizing. We've seen an increase in the use of ACH and PayPal and bank transfers, those kinds of things. If you look at the way those payments are administered, there's a cost associated with them. And more there's a security concern. Not so much that it's an insecure payment method, but it's very insecure for companies, for administrators to hold on to data, to banking data, to data that's very sensitive to consumers. What we're seeing is a transition to payment methods that are not only digital, but more safe and more secure in the sense that you don't need to capture as much personal information. From our perspective, we see a lot of digital prepaid cards, digital gift cards of a variety of factors, and it really depends on the jurisdiction that you're in. In the States, there might be digital MasterCard or what we call open loop prepaid cards that spend like cash. They can be delivered instantly to the consumer or to the class member. Digital gift cards may be popular in other parts of the world where they act similar to cash, but again, they can be delivered not only at a low cost, but oftentimes for free or even at a discount. Because what happens is the networks that they ride on, or even the merchants that are behind those products, oftentimes pay for that. So when you're looking at large consumer class action settlements where there could be millions of payments, where you could pay millions of dollars in bank transfer fees or check fees, or you could actually make money by issuing these other products. And that's what we've seen in recent years is a huge shift in terms of how those payments are accepted. The other piece of that, Christi, is from COVID's perspective, and I think everybody would agree as we're all consumers. I'll hold up my phone here as a quick prop, not that you can see the screen, if I can open it up, but that's a digital wallet. So this is my Apple Pay. By show of hands, how many people have used Apple Pay in the last 6 months? Wow, that's a lot. So for those of you on the phone, that's 100% of the room just raised their hands. I will tell you that statistically, we do a lot of research. If you look at the use of digital wallets, 59% have started using digital wallets as a result of COVID for a variety of reasons. Contactless, they don't want to touch things. More payments are being received digitally. And the value of issuing a digital prepaid card in various areas of the world is you can put it right into your mobile wallet. You could spend it that way. A couple of other interesting statistics as a consumer. 58% of us have used QR codes since COVID, which, I mean, now you can't go to a restaurant without seeing a QR code. If you asked me what a QR code was 2 years ago, well, some of us might have known, a lot of us wouldn't know how to use it, but today it's just common. And that all ties into the digitization of our habits as consumers. And finally, 43% are using digital and gift and prepaid cards more frequently since COVID. And I think through this holiday season, you're going to see a lot more of that. So those are some of the things that we've seen as digital payments continue to take hold in this space.
Super interesting. So certainly I know that I'm more digitized as a result of COVID. I mean, we're all very comfortable with the platform that we're on today, much more so than we were 18 months ago as one example. But I just wonder, are there any takeaways? And we actually didn't talk about this in our prep, so I hope I'm not putting you on the spot, but are there any takeaways that you can talk to us about with regards to sort of currency, managing the cross-border implications of different currencies and settlements where you may be involved?
No, that's a great question, Christi, and it's one that's evolving, quite frankly. Take a gift card as an example, an Amazon card, which a lot of people consider like cash. An Amazon card in the United States is different than an Amazon card in the UK. It's different than an Amazon card in Australia. Even though it's the same company, there are different currencies behind that. So it's important to understand that wherever the settlement is being issued to, that you're matching the currency that class member is comfortable with. If you're using a network-branded digital card, they do some of the work for you. The cards can be issued in a number of different currencies, and oftentimes there's just the exchange behind the scenes. That just the same as when I'm here traveling abroad from the United States. I take out my card, I tap and pay wherever I go. Visa automatically does the conversion behind the scenes from US dollars to quid or British pounds. So there are lots of different considerations with that, especially when you have a settlement that crosses borders and you want to be able to distribute it at least similarly to each jurisdiction.
Got it. Very helpful. So I know that we're close to the end of our time together here, and we didn't get to talk with Kathleen about the sort of mass tort implications, right? When there are global cases that may be resolving through different statutory regulatory mechanisms globally. I know that her firm has been, for example, involved in the breast implants litigation and has had some experience with that. But we only do have about 2 or 3 minutes left. I don't know if there are any questions from the audience. I don't want to ignore those. If there are questions, let's take those now. If not, I'd love, Kathleen, for you to give us a minute or two, if you have time, on the mass tort questions that we talked about a bit. Are there any questions in the audience? Okay. Well, let's take those 2 minutes then that we have left and let Kathleen chat with us really briefly about some of the mass tort implications where there are competing cases globally.
In France, we have different class action, but they are in fact ineffective. We can't use them because the customers are represented by association, and association doesn't have all the means for make a class action successful. We have, since 2014, created less than 6 class action different. Despite the specificities, each of this group action meets common condition. A group action can be filed at least with 2 consumers which believe they have suffered some harms as a result of the same breach of duty by a professional. The action must be brought by an officially approved association that has been in existence for at least 5 years. The system is ineffective, and these actions are competitive by grouped action, mass tort action. The French system of mass tort action is the same as the common proceeding that we can use, but the difference is that we have hundreds or thousands of clients. In the case of mass tort litigation involving many victims of different nationality against the same French professional, we brought the action before the French courts individually against the defendant, which is in France, in the form of the classic procedure involving several hundreds of thousands of claimants. Mm-hmm. Our firm is used to practice the air crash cases. In this particular case of air crash accident, the main activity of our firm where the family members of the deceased passengers bring the claim before the French courts against both the airline and the manufacturer and then in their insurers. In such case, the beneficiary are the victim of the same damage, but the calculation of the compensations, they should be aware, cannot be based on a lump sum as it is previewed in the case of class action in France, but on the application of the judicial and legal provision related to the compensation of damages, which differ according to the family relationship, the income of each direct victim, for instance. We are also currently involved in the PIP scandal, which is a breast implant scandal. Several thousand of plaintiffs have brought different action before the several French courts in this scandal. The responsibility of the PIP company and the certifying body TÜV, which certifies the defective processes in French, are being sought. Our firm is leading 3 mass actions before the commercial courts of Toulon on behalf of several hundred plaintiffs or different nationality of implant wearers, of beneficiaries of implant wearers, as hospitals and doctors who supply the PIP prostheses. These collective actions were initiated before the entry into force of the health class action that we have in French law, and the responsibility of the certifying body could not have been brought anyway in this framework because it is not neither a producer, nor a supplier, nor a provider using PIP prostheses. The issues addressed are those of the applicable law, the jurisdiction of the French court, the liability of each of the 2 professionals, and the term of compensation for the claimants. Mass tort litigation involves a legal and procedural investment by our firms. The settlement of such disputes also involves a titanic administrative work in the simultaneous processing of all the client's files. It is necessary to ensure that each of the client's file is complete. Identity of the client, document support, justifying loss, bank details, document required for the handling of funds in order to ensure that compensation will be passed on the person really concerned. This requires efficient and rapid organization of the processing of customers' information. These time-consuming steps are essential to the proper management of such a large file and represent a significant part of the work carried out. In France, we have a specific system for the fund transfers. Every lawyer is obliged to have a bank account special in a special professional organism of bank, which is called CARPA. In this CARPA, all the sums handled by the lawyers on behalf of their client must pass therefore through a single account opened in the bank in the name of the CARPA. This transfer fund enables the CARPA to ensure the transaction is lawful, source and destination of the funds, reason of the payment, and to check that a provision has been made, which helps to avoid payment incidents. The intervention of the CARPA thus guarantees the transparency of the operation, the availability of the money for the client.
Great. So look, I think the takeaway there is, and I know that people may want to chat with you during the break some more about that. The takeaway there, though, is that we've covered 2 or 3 different kinds. We've talked about mass tort litigation. We've talked about consumer litigation. We've talked about securities litigation. All of these group litigations that we've talked about, in particular the case studies, do involve parallel proceedings. They involve competing or complementary cases in other jurisdictions, in other countries, sometimes within the same country, sometimes regulatory, sometimes civil. And really what's important here is these kind of networks that we create at these sorts of events, right? So that we can learn more about what's going on in all of these proceedings, really share information to the degree that we can, and learn from one another about the best way to proceed and the best way to protect the rights for asset recovery and for claims in these matters. There's a lot to talk about here. Any one of these topics could have been an entire panel by itself, obviously, but it's something we're all very interested in, having committed our careers to it. Thanks for having us. I know any of us would be willing to take questions separately, contact us directly through the organization or otherwise. And you guys enjoy the rest of your day there. Again, I wish I were with you. Hope it's successful for everyone. Thanks.